Jennifer first asked me to talk about the latest case decided by the Supreme Court about TPS. And we'll walk through it. We'll walk through some of the law. We'll walk through the effects, at least as far as we know so far, because it was just decided a month ago. And then we'll talk a little bit, I'll switch to the agenda actually. We'll talk a little bit about how this intersects with the American Dream and Promise Act, where that is right now, which is, that larger immigration bill that has already passed the House. And then there are a couple other memos and guidance that I received some questions on that I figured would be helpful just to kind of give you the gist behind them. So these are some of the latest things, but as Jennifer noted, that there's often a lot of other cases going on, a lot of other changes happening. Under Trump, things were changing a lot, but under Biden, it's still changing a lot. Things are still, at least from the more progressive point of view, not where we'd like to see them. And I'm happy at the end to answer questions and to talk about, since I know that a lot of us are local, to talk about some of the more local changes with immigration detention too. I didn't put that in the agenda, but happy to talk about it because it's definitely something that, we're working on a daily basis. Okay, so the Sanchez case. This case was decided in June, so just over a month ago, and it was actually a 9-0 decision, which was the majority, not the majority of cases that were decided by SCOTUS, but the largest percentage of cases by SCOTUS, or the largest percentage of decisions by SCOTUS this year were actually 9-0, which I was surprised to see. And this opinion was written by Justice Kagan, no dissent, obviously, because it was a unanimous decision. So forgive me in advance, because this is going to get kind of academic. I feel like this case is a good, it just indicates how academic immigration law can often be in a way that is adverse to what you really want to see as a functioning immigration system. When we get to the conclusion, the decision, and what this means, I have a feeling people will be frustrated because it does feel very academic in that it's reliant on the specific text by Congress. Of course, that's how our country is structured, and that's how SCOTUS the Supreme Court is required to determine or to make decisions, right, is based on the text of what the legislature passed, with, of course, some interpretation as needed. But this case in particular really goes back to the text, what the text does and does not say, maybe in a way that the legislature meant, maybe in a way it doesn't mean it, but we'll get to that. So I'm going to start with a little bit of, here, I'm just putting myself away. Okay. This was actually the first paragraph minus the last sentence of the decision. I thought it would just be helpful to kind of frame what this case was about. So I've put in red pieces that I think are going to be especially important for us to understand what this case is. So the petitioner, Sanchez, entered this country unlawfully from El Salvador. And more specifically, he entered without inspection, right? So he came into the United States without passing through a port of entry and without being admitted, which will be important later, for purposes of immigration law. So he was here without a lawful status for a while. And I think that was late 90s that he came into the US. Then it goes on, years later, because of unsafe living conditions in that country, in El Salvador, the US government granted him temporary protected status, which we'll talk about a little bit later. I think most of you probably know what temporary protected status is, but we'll get into it. And that status entitled him to stay and work in the United States for as long as those conditions persist. So as long as the unsafe living conditions in El Salvador persist. Sanchez now wishes to become a lawful permanent resident of the United States. And the question here is whether the fact that he got TPS, the conferral of TPS, enables him to obtain LPR status despite his unlawful entry. LPR is something we'll talk about a lot. And again, most of you probably know this, but as it's indicated here, it stands for a lawful permanent resident. Same thing as having a green card. So you can, a lot of people just say in common parlance, green card holders, lawful permanent residents, same concept. So that's this is really the case. And there are a few things I want to review before we get into the question that the case was exactly asking. There are some terms of art that you see in immigration law that are important to understand prior to really understanding what this question is. First and foremost, the concept of admission, right? Which, as defined by statute, is quote, the lawful entry of the alien, which of course is a term we don't like to use, but is codified in our statutes. So of the non-citizen into the United States after inspection and authorization by an immigration officer. So if you're thinking about this like in, daily, what this means for daily entrances into the US, it would mean going to a port of entry, coming through an airport, you're going through customs, your passport is being checked, it's ensured that you have some visa or some sort of non-immigrant status to enter the United States, and you're kind of approved to enter, right? So that's what we call an admission in immigration law, and it will come up again shortly. Importantly, and again, we'll talk about this in a little bit, status, your immigration status is not equal to a lawful admission. You can have lawful status, at least according to our laws, according to the Supreme Court, without having a lawful admission, and actually vice versa. So these are two different concepts. Temporary protected status is one example of an immigration status, right? Temporary protected status, otherwise known as TPS, is something that the Secretary of Homeland Security designates. So the Secretary decides what countries may be designated as, or what need people who are from other countries who are not US citizens may qualify under temporary protected status to have temporary protected status in the United States according to their country of citizenship, right? The reason they're designated is because they're unable to return safely to their country, or for whatever reason, the country cannot handle if there were to be like a larger influx of return of its nationals from the United States. And this could be for several reasons, including ongoing armed conflict, so civil wars, environmental disaster, hurricanes and earthquakes. So, Haiti is a good example of this, given prior earthquakes when it first received TPS status, and other sorts of extraordinary and temporary conditions. Oftentimes we see it's related to natural disasters or environmental disasters, but it's up to the Secretary of Homeland Security to figure out which countries would qualify for this designation that would then qualify people who are in the United States, who have that citizenship that then gets the designation to be protected from deportation, to be able to remain here and work here lawfully. It doesn't mean that they had to be, and in fact, often it isn't the case, that they were lawfully admitted into the United States. And this is the whole crux of the case here. They could have entered without inspection and not had lawful status prior to receiving TPS. And of course, like anything else in immigration, there are a number of reasons why, based on criminal history or other sorts of factors, you may be denied the specific status. So right now, the designated countries are El Salvador, Haiti, Honduras, Myanmar, Nepal, Nicaragua, Somalia, Sudan, South Sudan, Syria, Venezuela, and Yemen. Venezuela and Myanmar are the most recently designated. And because of the timing, they actually might not fall under this case. I already mentioned this, but to get, so people who can get TPS may not have been lawfully admitted. And in fact, according to the statutory text for TPS, it's not an eligibility requirement to qualify for TPS. So someone can enter without inspection, someone can be here without lawful status, can be here without authorization, and they can still be eligible for TPS. Another term of art that's important to understand for this is adjustment of status, which is essentially the process through which someone becomes a lawful permanent resident, or they get their green card while they're in the US. So it doesn't cover people who, this term doesn't refer to people who become a green card holder, get their green card while they're abroad, right? If they're doing it while they're abroad, they go through the consular process. adjustment of status is specific to people who are getting it, who are adjusting their status while they're in the United States. And there's a important reason why adjustment is a possibility for folks. The major one, right, is that depending on how someone entered and how they were in the United States, and depending on how long they were in the United States without lawful status, they may be subject to 3 or 10-year bars on them returning to the United States. And I have this later too, but I believe it's 180 days if you've been here more than 180 days without lawful status. If you leave the United States and it's triggered by you actually departing the United States, you'll have a 3-year bar on you returning. And if it's over 365 days, it would be a 10-year bar. So if someone, if they departed and because of their status or lack thereof, while they were in the United States, were subject to this bar, they would not, even if they were able to get a green card, they wouldn't be able to return for a number of years. So there's an important reason why this adjustment can happen in the United States. So they're not going to be subjected to those lengthy bars. Okay, so the real question is, how do you square someone who entered without inspection, was not admitted, and subsequently got TPS with the admission requirement to adjust? So I guess an important hole to fill here is that in order to get adjustment of status, you have to have been admitted. And so here we're talking about this case in which Sanchez entered the United States without inspection, was here for a few years without lawful status, then based on circumstances in his home country, was able to get TPS, which gives him lawful status, but as we'll get to, does not give him a lawful admission. Okay, so status versus admission, and this is where I'm saying it gets pretty academic, right? Because I think that normally when you're talking about immigration, if you're just talking more broadly about it, you're not going to get into these sorts of specifics. But they do qualify as two different things for purposes of immigration law. So TPS, temporary protected status, is a non-immigrant status, which essentially means that they are allowed to be here in the United States, but it's not a permanent status by any means, right? That's why someone might be interested in getting a green card, becoming a lawful permanent resident, then you're considered in an immigrant status. And in order to get the status, right, it doesn't turn on admission, this specific status anyway. And there are other sorts of examples of people who maybe weren't admitted, but then later get lawful status. So for example, someone who entered the United States without inspection, but then applied and received asylum, then they're in this asylum. They have lawful status because they received asylum, but they were not admitted into the United States. And now admission is not a prerequisite to get TPS status. So Sanchez himself, right, was not admitted prior to applying for and getting TPS. And this can also happen where you have a lawful admission, but then you don't have lawful status. So for example, someone who enters on a non-immigrant student visa, they first enter and they're admitted into the United States because they have this temporary visa. But if they overstay that visa, then they're going to fall out of lawful status. So that they would have had a lawful admission, but then not lawful status. So and these two examples actually were used by Justice Kagan in her opinion to indicate that these things are different. Status and admission are different in terms of, for purposes of how immigration law applies to you. Hopefully this all makes sense so far. Okay, so then the question becomes for the court. They recognize that TPS is a thing. They recognize that status and admission are two different things. So they're going to look at the text of what creates the ability to get temporary protected status and try to understand whether getting the TPS status, becoming a TPS holder, means that you have been admitted, or does it mean that you just have status? And that's going to be important for adjustment of status. So they're asking, when Congress said TPS holders shall be considered as being in, quote, lawful status as a non-immigrant, which is what the actual text says, that once you have TPS, you're in lawful status as a non-immigrant, so you have status. Did they mean that TPS holders should be treated as if they have also been lawfully admitted or paroled? Was that part of Congress's intent? And before this decision in June, there was a circuit split, which means, we have these different circuits within the United States. So you have district courts, and then you go up and it's a court of appeals, and those courts of appeals, we have several different circuits there. Once you get to the court of appeals level, if you start to see different decisions in, say, for example, our court of appeals, which is the third, and California's, or the California areas anyway, which is the ninth, once there are differences at the circuit level, that often requires the Supreme Court to step in, or the Supreme Court will really decide to step in and settle which one is right. Because otherwise you have, in decisions that don't agree within the same country, depending on where you are. So there could be a person, for example, who is a TPS recipient or a TPS holder who did not have admission in, I'm just using this as an example, this isn't the actual split, in California, who's able to adjust, and TPS holders, same set of circumstances, in New Jersey, who's unable to adjust because there are different decisions. And that's obviously something that we don't want as a country, and does not seem fair. So the court took it up, in part because we have the third, which is our circuit, fifth and 11th circuit, saying that individuals who have TPS status have a lawful status, and based on how that status has been given to them, the recipients must be treated as though they had been inspected and admitted. So it's as though they have been lawfully admitted into the United States. That was the reading by those three circuits. And then in contrast, you have the Sixth Circuit, the Eighth Circuit, and the Ninth Circuit saying that TPS does not qualify as an admission for purposes of adjustment of status, because you have admission and status as two separate concepts. And they talk about they refer to one specific example, and this comes up several times, but one specific example of why an admission and status are not the same. U visa recipients. So U visas are the visa that you can apply for if you have been the victim or the witness of a crime. And the concept being that you're going to help law enforcement investigate and potentially prosecute. And so they need to keep you in the country. And so you can apply for a U visa with the help of like your local law enforcement. Sometimes judges can sign this thing that you then apply for to get a U visa to prevent your deportation. So anyway, U visa recipients can be eligible for lawful permanent resident status if they were either admitted to the US or, quote, otherwise provided non-immigrant status. So this is just by way of an example, talking about why admission and status are two different things. And we don't really have to get into the U visa question, but this just demonstrates why in immigration law, we're going to look at admission and we're going to look at status as two different things. And that's what the Sixth, Eighth, and Ninth Circuits followed. So all because in order to get adjustment of status, you have to have had a lawful admission. This has created problems because the TPS statute itself does not say that to get TPS status, when you have TPS status, you also have a lawful admission. So some circuits were saying, yeah, of course, you're going to be treated as if you've been admitted. Other circuits are saying, no, lawful status does not equal an admission for purposes of adjustment of status. Hopefully that makes sense. Okay. So this is getting into the actual text of adjustment of status, right? So there are people who come in with non-immigrant statuses. There are lots of different sorts of statuses you can be in. that then want to adjust status to become a lawful permanent resident. Today, we're really only talking about TPS, but there's a whole lot of statutes that talk about people in lots of different statuses and how they might be able to get lawful permanent resident status. And that's all, I believe it's all under 8 U.S.C. 1255. But there are two different pieces of that statute that the court looked to make the decision in the Sanchez case. So they looked to first Section A, which says that an applicant for lawful permanent resident status must be inspected and admitted or paroled into the United States. So that admission is a requirement. And then Section 2, they're talking about a person who has worked without authorization in the past. So they were not legally allowed to work, but they did. They can adjust status only if their presence is, quote, pursuant to a lawful admission. So here you have two sections that are making explicit that if you want to adjust status, you have to have a lawful admission. The second is more particular because it's about people who are applying for employment-based adjustment of status. You can adjust status a number of different ways. Two biggest ones are through employment or through your family. And in this case, because Sanchez was actually trying to adjust under an employment-based adjustment, they also looked at 1255K, which talks about the requirement for lawful admission based on the fact that he had worked without authorization. So the court kind of looks at both of these pieces of 1255 to find an explicit acknowledgement that there needs to be admission in order to adjust your status. And that's going to create a problem for people in LPR status because the text of the statute does not explicitly say that once you get LPR status, you have also been formally admitted. So it again feels very academic, right? Because it's about the text of the statute and it's about something that feels very artificial, at least in my opinion, about trying to get an admission into the United States. An admission, right? I know I've said it multiple times, but admission is not just purely entering the United States. It's this specific process that you go through and you're actually lawfully admitted. So in this case, they decided that based on the text of the statute for people who get TPS, that TPS itself does not admit individuals. It just provides the lawful status. So if you have those two pieces, the lawful status and the admission, TPS, by getting TPS alone, you get lawful status. It doesn't mean you've been admitted. The statute, the legislative text itself is actually silent about admission. Congress could have easily added a provision that said, once you receive TPS, you not only have a lawful non-immigrant status, but you've also been formally admitted for purposes of immigration. They did not say that. It is silent, and therefore the court read in the fact that Congress did not intend to also grant a lawful admission. So TPS alone is not going to make someone who entered the United States without inspection or wasn't admitted eligible for adjustment of status. They need those two pieces. And having TPS cannot erase the disqualifying effect of an unlawful entry. Therefore, their holding makes it so that a TPS holder is not qualified to adjust status from within the United States. Now, I have a couple asterisks there because there's a little bit more discussion on this. There's a little bit of an open question. And also remember that this applies to adjusting status within the United States. It's not outright saying that they cannot qualify for a green card, but it's saying that so long as they try to adjust status from here within the United States, they won't be able to do so absent a lawful admission. And because, I should go to the next slide because I think it's on there, because a lot of TPS recipients are people who enter the United States without inspection. They're people who don't have lawful admissions. If they are ultimately able to and otherwise eligible to adjust to LPR status, without a lawful admission, they're not going to be able to do it from in the United States, and they would instead have to leave the United States and go through the consular process, right? Which is the other way that you can try to get LPR status, either here through adjustment of status or abroad through the consular process. And when I say abroad, I mean in your home country. But as I mentioned at the beginning, once you depart from the United States, if you entered and were here with unlawful presence, you're going to be subject to certain bars on reentry. So you'll be stuck outside the United States for 3 years or 10 years, depending on how long you were here and did not have lawful status. So for example, they don't get into this in the case, but just thinking through the facts of Sanchez's case, he arrived and entered without inspection, and he worked from the late-ish, maybe 97, I think, late-ish 90s through 2001 without authorization and without lawful status. That said, if he was here for over a year working, did not have status prior to getting TPS, if he were now required to leave the country in order to try to become an LPR, get his green card, he would be subject to a 10-year bar. Now, there might be other specifics you have to keep in mind. Right? There are some waivers for these sorts of bars, but that gets into the like more personal case. Was not discussed by the Supreme Court, but this all matters a lot, right? For the tens of thousands of TPS recipients who may have this pathway to having more permanent residency here, who now cannot because they entered without inspection, and because of the specific text of the statute that conferred TPS on them, they don't have the lawful admission piece that they need in order to adjust their status. And just thinking through this practically, if beyond the just pain of having to leave for 3 years, 10 years, or be barred from re-entering for 3 years or 10 years, and trying to adjust, or not adjust, but trying to get LPR status from abroad, that's not only costly, but lengthy separation from family, right? So this is really concerning to folks with TPS who may have a path toward a green card. So one open question, and the court puts this in a footnote, which I think a bunch of advocates have kind of hung on to because it provides a little bit of hope. There are actually two good pieces of hope, but the first being the court did not explicitly rule and said this in their footnote that they were not going to rule on this, whether a reentry into the United States upon advance parole could qualify as an admission for purposes of adjustment of status. So advanced parole, right, is this thing where you're here on whatever status. This happens a lot with DACA recipients. They want to go abroad for some reason. It might be educational, it might be, family emergency, someone's really ill. It's not usually something like vacation. It's normally something where it's pretty serious, and you need first the permission, DHS, that once you leave, you'll be able to re-enter. And they call that advanced parole. You get the permission in advance, and it's intended to ensure that once you come back to a port of entry, you're able to enter the United States. There's been an argument in the past, still an argument, that if you get advanced parole, you leave, you come back, once you go through that port of entry with your advanced parole, you have a lawful admission. And so the question, the court did not look at the question of whether someone who has TPS, who got advanced parole to leave the country to see a sick relative, and then upon return got lawful admission, whether that lawful admission is sufficient for purposes of adjustment of status. It could be. However, there is an administrative opinion by the AAO, which is under USCIS, from August 2020, called Matter of ZRZC, which says that, kind of forecloses that possibility, right? Says that TPS authorized travel, so someone with TPS who gets advanced parole, once they return, they still will not have satisfied the requirement of lawful admission. Now, there's a little bit of hope still because that's an administrative decision. It's not decided by a federal judge or federal court. That could be challenged in court. I think some advocates are thinking that maybe that's one of the next fights for TPS folks who want to adjust their status. But as is written right now, together, the Sanchez decision and the ZRZC decision really precludes adjustment of status within the United States for people who have TPS. So not good, right? Another thing that the court flagged, however, was that, because all of this depends on the words of Congress, on the legislative text, this can change through legislative action, like everything in immigration. But this in particular, because it's a small little step forward that Congress could take, could be resolved by Congress, and that hole could be closed such that Congress could say, if someone gets TPS, they not only have lawful non-immigrant status, but they also have a lawful admission. And so those things together, they could pursue a green card. And the court actually, I took this quote from the decision, the court, or Justice Kagan, explicitly refers to the legislation that's currently pending in Congress, the American Dream and Promise Act, which, and you'll see the text right here, makes it so a TPS recipient having been inspected and admitted to the United States, I'm sorry, I didn't include some of the other text, but a TPS recipient would have been considered admitted into the United States and have that lawful status. That would resolve all of this, right? So assuming that this legislation may be going forward, or any legislation that wants to plug this hole, it is fixable. But right now, it looks like the options for TPS recipients who want to adjust status, that option is foreclosed. Of course, and I need to add this caveat, always anyone who might fall into this category should speak individually to an attorney. There may be other ways to access relief, and it has to be an individualized analysis. But broadly speaking, this is what the court has decided, so that folks who entered without inspection, don't have a lawful admission, they will not be eligible for adjustment of status. That's Sanchez. And that's a lot, and I'll make sure that there's room to ask questions. But I think that also kind of leads us into the next topic, which is the American Dream and Promise Act of 2021. So some of you may be pretty familiar with this. The act was introduced in the House in March, had a lot of co-sponsors from the start, passed the House March 18th, even more co-sponsors, all Democrats. And it's supported by the Biden administration, right? So it has a lot of Democratic support. The essence of the bill, the gist of the bill, and there are a lot of particulars, right? But the gist is that it would create pathways to permanent residency for DACA recipients and for TPS and DED recipients. DED is deferred enforced departure. So DACA recipients would first be able to get this conditional permanent residence for up to 10 years, and then they'd have an opportunity to adjust to lawful permanent resident status. And then once you're in LPR status, right, you're able to follow that path to naturalization. And then TPS would also, people who qualify for TPS or DED, or they have already received those statuses, will qualify for LPR adjustment. And I list out the countries here because the bill itself does not explicitly include Venezuela and Myanmar because it was written prior to those designations. So I'm not entirely sure what would happen for folks who have TPS from those two countries in particular. That might be a question that Congress people are thinking about. But this is the gist of the bill, and fortunately has passed the House. So there were two Senate committees that already have talked about it. The first was back in March. I can't remember what it was, maybe transportation, and it was a not so commonly discussed Senate committee. And then the Senate Committee on the Judiciary discussed the bill on June 15th. Now, there's I'm sure you've all heard that there is skepticism as to how far this bill will go, in part because in order to pass the Senate, it needs to get support from at least 10 Senate Republicans. And just given the divisive nature of politics right now, that's somewhat up in the air. But it's still an open question, and certainly something that I've presented on this in the past of the percentage of, or the public opinion around DACA and TPS, and by and large, the American populace, believes that DACA and TPS recipients should have a pathway for more permanent residency. It's just a question as to whether or not we can get our Congress people to agree. Now, I just also wanted to note two things related to this. First, actually, they're both related to DACA. DACA, right after the court's decisions, the Supreme Court said the erasure of DACA was insufficient. Trump didn't try to repeal DACA. And during November, December, there was another court case that was challenging the fact that USCIS, the Citizenship and Immigration Services, had not kind of reopened for process new DACA recipients or extended the length of work authorization. A judge then ordered USCIS to do that, to reopen for new DACA applicants. But we're hearing a little bit that it's a pretty slow process for people who are applying for DACA right now. So advocates are pushing for that to go faster, in part because we still have this pending case in Texas by the judge before the judge who had ruled against the DAPA back when Obama had proposed DAPA, which was similar sort of relief, but for the parents of people who qualify for DACA. So advocates are worried about that. It's actually been pending now for 6 months. I'm not entirely sure of the latest on that, but that's in part why advocates are pushing for quick processing of USCIS applications to try to get people DACA prior to that decision out of Texas. But of course, the biggest relief would come from legislation. So that remains to be a big focus for advocates. And now just a couple more things before we turn to questions. There have been a number of different memos and guidances published by a lot of different authorities in the immigration sphere. So I'm just going to go through a couple of them. The first one actually comes out of another Supreme Court case, which was decided this year related to immigration. It was a Gorsuch decision that was all about this thing called the NTA, the notice to appear, which is what is sent to you it kind of starts your removal proceedings. It's sent to you. It indicates, who you are, where you're from in terms of your country of origin, and gives you, or is supposed to give you, the time and date for when you appear before an immigration judge. But oftentimes what ICE was doing is that they were issuing an NTA that included the first couple things, your name and your country of origin, but left blank the time and place of when the removal hearing would be. And then subsequently would send a second NTA that would include the time and place. And for purposes of cancellation of removal, which is one possible relief, right? When you're in removal proceedings, it mattered what time you got your NTA, because it would stop the clock. For cancellation of removal, you have to be here continuously for a certain amount of time, and once you get the NTA, that clock stops, right? The court decided that having those two separate ones, the first NTA not having the time or place, that was insufficient. That's not going to stop that time clock. So it was a good decision. It affects a subset of people who are currently in removal proceedings or who were in removal proceedings. And consequently, ICE decided, they issued this guidance saying that because of that Supreme Court decision, for people who were either denied cancellation of removal or did not pursue it in the first place because they did not meet that continuous presence requirement, because that insufficient NTA, they thought the insufficient NTA stopped the time clock, they're able to open a motion or to file a motion to reopen their case and fight it again. Of course, people are always able to file a motion to reopen, but this guidance in particular says, orders the lawyers for ICE to either join that motion to reopen or to not oppose it. So they're kind of taking a step back and saying, okay, we're not going to actively oppose that because of the decision by the Supreme Court. And I think this, Jennifer, I think this was one of the things you had a question on. So with, if people are affected by this change, not necessarily change in the law, but clarification of the law, they are able to work with their attorneys to file a motion to reopen. And through November 16th of this year, ICE is ordered not to oppose that motion to reopen, which can go a long way. It's obviously really helpful when you have ICE either joining you or not opposing you. Enforcement priorities remain the same as they did when they were issued under the Biden administration on January 20th. But there have been other sorts of memos that kind of further clarify or further put in place those enforcement priorities. So, the earlier enforcement priorities were clarifying what ICE is doing in terms of targeting people or, issuing their notices to appear, to put them in removal proceedings. The more recent memo was an EOIR, or Executive Office of Immigration Review, memo to judges, immigration judges, and the Board of Immigration Appeals, kind of further establish these priorities and encourage judges to really implement them and what they're doing in the courtrooms. So it encourages judges to ask questions about whether the individuals appearing before them remain an enforcement priority. So they ask both, their attorneys and ICE, and to really focus the court's resources, which are always limited, on cases that meet the enforcement priorities, which, just as a reminder, there are three subsets of priorities. One, people who either have alleged or have been convicted of certain terrorist activities, that falls under national security, border security. So it's priority for the Biden administration to focus on people who entered the United States without inspection at the southern border, either on or after November 1st. And then lastly, public safety, or people with aggravated felonies, or really convictions for, we can get into a long conversation about what an aggravated felony is, because it's a term of art in immigration law, could include a number of different things. But essentially the idea is people with certain convictions would qualify as a removal priority. And therefore, under this memo, judges should keep in mind how they're using their resources in the courtroom, should focus on people who fall under these priorities. Lastly, and just like a little note, I'm actually curious to see how this one will play out, but another memo from the EOIR created a specific docket. So a specific set of judges that are going to consider the specific subset of cases for families who crossed the southern border and were then placed in alternatives to detention. So weren't detained, but maybe were placed on ankle monitors, or more likely, asked to check in regularly with ICE, or ICE regularly checks in with them. I think this is a part of trying to make immigration courts more efficient. As I think everyone on this call knows, there is a huge backlog, and much easier said than done to try to eliminate that backlog and get things moving. The idea here, I think, is to try to expedite these specific cases for families who are currently in alternatives to detention, and does not set any requirements for immigration judges, but does, for those who are going to work on a specific docket of cases, tells them to endeavor to complete the cases within 300 days after the first hearing, which, these sorts of cases, when they're not detained, they're not expedited in the same way, and they can go on and on and on. So that's the last memo I will cover. Happy to answer questions. I'll stop sharing my screen. And